the first thing I want to talk about today are boundaries. And the first thing I want to do today is just to ensure that as a residential conveyancer, you're adopting the right strategy with regard to boundary issues. It is impossible in a standard conveyancing process to identify a legal boundary. A title plan reveals a general boundary and therefore is of no consequence. As far as the description of the property and the property register, that is going to be so imprecise and is likely to be a sort of postal address that that's of no consequence either. So I think all you can do to start with is ascertain at the start of a transaction whether there is any boundary sensitivity. So asking the client what they're intending to do with the property is important. The client might tell you that they don't intend to do anything other than live in the property, in which case that's fine. The moment the client alludes to the fact that their intentions are to carry out development work relating to the property or altering the property, etc., then boundary sensitivity could be an issue. For the last 18 months or so, I've been involved in some consultancy work in connection with a boundary issue for a developer who bought a site, who demolished a house on the site and who built two very expensive, indeed very beautiful houses on the site. During the construction phase, they encountered a problem with a neighbour concerning a strip of land that's approximately 2 metres in length and approximately 6 centimetres in width. But the neighbour immediately saw an opportunity to level the score with regard to their objections relating to a planning application that was submitted by the developer. The objection from the neighbour didn't find favour with the planning authority and permission was granted notwithstanding the objection. So there was a bit of private grief before we start. And the neighbour then was able to manufacture a situation with regard to a potential dispute concerning this ridiculously tiny area of land. That ridiculously tiny area of land has led to 2 applications being made to the land registry to determine boundary and county court proceedings, which are still ongoing. Legal costs incurred so far, probably 60 or 70,000 pounds. Ultimately, if the matter goes to trial and the 2 land registry determined boundary applications are also contested, probably 250, 300,000 pounds for a ridiculously small area of land, as I say, that's of no consequence. So important that clients understand the difficulty that you have with regard to boundary identification and the potential problems that can arise in connection with boundary disputes. So does an objective generate boundary sensitivity issues? And does the transaction itself generate boundary sensitivity issues? The seller disclosing to you that there's been a dispute in the past, or that a boundary fence or wall has moved, or something of that nature could generate the need to investigate the location of boundary, or to warn the client, probably the better course of action, that it will be impossible to ascertain boundary. So first things first, with regard to boundaries, is the boundary location an issue with regard to your transaction?